Hello, everyone. My name is Ariella Wagner. I'm the founder of SunRay Construction Solutions, a national construction document service. We help subcontractors, suppliers, general contractors secure their lien and bond claim rights. Today, we have a fabulous and very much needed webinar on Bankruptcy Happens, how to deal with it, with the incredible Jordan Rappaport, who has been practicing bankruptcy law for over 15 years. And without further ado, I would like to introduce Jordan Rappaport.
Good morning, everyone, and happy Friday. Today, we're going to be talking about bankruptcy and construction liens and how they interrelate. Let me give you first a 10-15 second description of myself. I am a bankruptcy attorney. That's the sole focus of my practice. I have a small boutique bankruptcy firm in Boca Raton, Florida. I've been practicing between 24 and 25 years. And I deal with issues involving construction liens and bankruptcy on a daily basis. Today, we are going to be talking about various issues involving construction liens and how you get caught up in bankruptcy with construction liens. Let me show you first the agenda. We're going to be talking first about bankruptcy and how you got there. How do you, as a vendor or a supplier, get dragged into the bankruptcy, whether you like it or not? Then we're going to be talking about the different types of bankruptcies you might encounter. It's important to understand the type of bankruptcy you're going to be dealing with, because your reactions and those things you need to do to protect your liens or protect your hard-earned money will change depending upon the type of bankruptcy. Then we're going to talk about the automatic stay and how important it is to pay attention to what you are doing and potentially how you're collecting your funds and potential upsides and downsides to the automatic stay. After that, we're going to talk about actually the most important thing: how do you get paid? We're also going to talk after that about executive contracts and assumption by debtor in possession. That's a bit of a wonky word or word choices, but we're going to talk about how you get involved and how you can continue to work with a debtor in possession and ongoing Chapter 11 and still get paid. We'll go through that. Lastly, the last two issues we're going to talk about is your particular business and how bankruptcy may in fact help it. Bankruptcy is not an end, but in many cases a beginning. And I have personally helped many businesses reorganize and emerge even more successful than before. And lastly, we're going to talk about personal liability. A lot of businesses are mom and pop, and people sign on personally for vendors, or they give personal guarantees for leases, especially leased equipment. We're going to talk about how how your personal liability is dealt with in bankruptcy, and how maybe it's something you wish to consider. As we go through this, it's important for everyone to understand that information is power. Information is valuable. If nothing else, you will get valuable information from hearing what I say today. There's no cost to this, so to take down this information, or in the future you can call me and I'll give you my contact information. But this information, while it may not affect you today, invariably in today's environment, it will affect you and your business at some point in time. So let's first talk about bankruptcy. Well, how did I get here? How did I get dragged into bankruptcy? Well, first let's talk about your business. A lot of general contractors, they hire subcontractors. And if one of your subcontractors files a bankruptcy, you're involved whether you like it or not. If a deposit was given, that deposit may be part of a bankruptcy estate. So before using and accessing a deposit, you may want to consider the ramifications with bankruptcy. Have you supplied building materials? Have you paid for building materials and given them to a sub? Has a sub then used them and then filed bankruptcy? You would need to determine whether or not money is owed to or from this subcontractor and how it affects you with the bankruptcy, because you may be a creditor in the bankruptcy. Even more importantly, if you owe them money and they file bankruptcy and you pay them instead of paying a bankruptcy trustee, and a bankruptcy trustee is the court-appointed official who oversees a business once it's closed down in bankruptcy. If you pay the wrong person, you may find yourself in a very difficult position. So these are things that you have to ask yourself. And if you don't know the answer, seek counsel, because you don't want to end up paying the wrong person and having to pay twice. I've seen it happen. Now, another scenario is where a property owner files bankruptcy. There are many people who find themselves in financial difficulty and fall behind in a mortgage and file a bankruptcy, be it a Chapter 7 or 13. And I'll go into those types in just a minute. But if a property owner files bankruptcy and you've done work on that property and are owed money, you need to assess where you are and figure out what your next step is. Did you file a lien? Because if you haven't filed a lien before the bankruptcy is filed, you can't file it after. And I'll go into why you can't file it after, but it's called the automatic stay. But suffice to say that once that bankruptcy is filed, it's too late to file a lien. So using SunRay to file a lien as soon as you're legally able to and following up on proper lien recording is extremely important because it'll put you in a better position. Another issue is if you're holding a deposit, are you able to access that deposit once the bankruptcy is filed? Well, that's not such a black and white answer. It depends upon the type of bankruptcy. But think of it this way. If you find out your property owner, the property you're working on, the owner of that filed bankruptcy, whether it's a single family home or a commercial piece of property or a large multi-unit hotel of some sort, you need to be aware that you will not be able to touch those deposits until you deal with the bankruptcy issues. Lastly, if you're the contractor, if you're a subcontractor and the contractor you're working for files bankruptcy, it's essentially the same analysis. Have you filed your lien? And even though the GC files bankruptcy, if the property owner is not filed bankruptcy, are you able to file a lien? In some cases, yes, and in some cases, no. You have to look at the particular aspects of the bankruptcy, but these are questions that should pop in your head once you find out that the contractor you're working for has filed bankruptcy. Even more important, do you continue working? Is the GC who filed reorganizing and continuing to work and expecting you to continue to work, or have they closed up shop and you're wondering whether you should work? Well, these are things that it's going to be a situational. It'll change situation to situation, but you need to analyze this, and you may need to contact an attorney such as myself to analyze this and give you answers to those questions. Now, I mentioned the different types of bankruptcy, and each type of bankruptcy has specific pros and cons for you as a potential lien holder. The one you'll probably most come into contact with is a Chapter 11. I have personally seen large real estate developers file bankruptcy here in South Florida. I've seen general contractors file. I am actually personally involved in various bankruptcies. And Chapter 11s are the common theme. If a business wants to try to reorganize, try to continue to operate, even if they're heavily in debt and there's some cash flow issues, a lot of times they'll file what's called a Chapter 11. A Chapter 11 is a reorganization, which means that there is no trustee appointed to close up and there is no trustee appointed to close up the business. It continues to operate, but under the close supervision of the U.S. Trustee's Office. Everything is done out in the open and under a microscope. In the Chapter 11, there's a lot of moving parts. There could be cash collateral issues. There could be 20 different types of secured creditors. There could be insurance companies, bond issues. There's a lot of moving parts in a Chapter 11. And if you find yourself listed as a creditor and owed substantial sums or have substantial sums on the line in a Chapter 11 bankruptcy, you need to be careful and immediately assess where you are and determine whether or not you need an attorney. There may be very important work that you will need to keep doing and you want to be paid. You may get phone calls from the people in bankruptcy saying, hey, why did you stop working? Well, you need to address that. And if they want you to keep working while they're in Chapter 11, certain safeguards need to be put into place so that you get paid. The last thing you wish to do is to keep working knowing you're not going to get paid. You also need to be careful of liens being stripped. What does that mean? Well, even if you properly filed a lien on a project you're working on, there are procedures within Chapter 11 cases wherein a debtor in possession, which is the entity that's in the bankruptcy, can seek to sell property out from underneath your lien and then determine the priority and extent of the liens. This is done in very large cases, and it's a very powerful function of a Chapter 11 proceeding. And you need to be aware of whether they're trying to do this or whether they're going to try to do this, and then you need to enforce your rights. Filing the lien was the right decision, but understand that that doesn't mean that it's a brick wall. In a Chapter 11 proceeding, a clever debtor can knock down that brick wall, and you need to be aware of it and protect yourself. Next type of bankruptcy is a Chapter 7. Chapter 7s are a little simpler than the 11s in that the business is shut down, whether it's an ongoing real estate project or whether it's a contractor. You will, in a Chapter 7 proceeding, you will no longer be dealing with the entity that filed bankruptcy. A trustee is appointed, and a trustee in the Chapter 7 essentially takes control of the business that has filed the bankruptcy. So whether you're owed money, whether there's work to be done, you'll be dealing with a whole new set of people. In this case, a Chapter 7 trustee. This is, if you find out that you're a creditor or listed in a Chapter 7 bankruptcy, it's not as big of an emergency as a Chapter 11 because it's not ongoing, but you still need to give it your direct and immediate attention. Chapter 7s can be either personal or business. So if there is somebody that owes you money, or heck, it could be an employee or employer of yours, if they file a personal bankruptcy, you also need to pay attention to what's going on and potentially file a proof of claim to get paid. And I'll go into that, but it doesn't have the same urgency as a Chapter 11. Now, but last but not least is a Chapter 13. Most vendors, suppliers, GCs, subs will not really get involved or be affected by a Chapter 13, except for one particular instance. In a Chapter 13 is always an individual, a person. And in some instances, that person, when they file bankruptcy, will seek to strip off liens from their house. So I've been involved in cases and personally filed plans wherein the property owner notices when they do a title search on a property if there's a lien for I don't know, let's say an air conditioning company or somebody that installed a sump pump or something else on the property, and it could be for a few $1,000s. But listen, if I did work in a house and I have a lien, I want to get paid that few $1,000s. That's why I filed the lien. Well, in a Chapter 13, if the value of the property is below what's owed in the first mortgage and your lien for whatever amount is essentially unsecured, they can move to strip it off because of the Florida homestead provisions. So, and that is easy to see by the plan they file. They actually file a piece of paper in the bankruptcy called the Chapter 13 plan, which will show in black and white that they are trying to deprive you of your lien, deprive you of your rights, and remove that lien. There are ways to object to that. If you do not pay attention to that, your lien will be gone and you will get pennies in the dollar. I've been on both sides of those cases, and I have to tell you that if you encounter that, somebody's trying to do that to you, you need to contact an attorney immediately to protect your rights. Now, let's talk about something that's pretty black and white, but can get very complicated very fast. The automatic stay. Section 362 is called the automatic stay in bankruptcy, and this is the most powerful function of bankruptcy, and this is the reason why companies and individuals file bankruptcy. Upon the filing of the bankruptcy, everything gets stopped in its place. It's a federal court injunction called the automatic stay comes into effect immediately, down to the minute of filing. And what this injunction does it stops all collection efforts in their tracks. So I'm going to repeat that because it's incredibly important, because if you're trying to collect money from somebody, or you're trying to file a lien, but you haven't filed it yet, you say, oh, I'll file it tomorrow, I'll file it 3 days from now, and you find out that the person that you're trying to file the lien against, or the property you're trying to file a lien against, is filed bankruptcy, you're stuck. You can't rush out and say, oh my God, they just filed, I need to do it right now. You are stuck. That automatic stay is instantaneously. Even one better. Let's assume you filed a lien today, and you found out a couple of days from now that, hey, somebody, the property owner or the construction company filed bankruptcy a couple of days ago. Maybe it took you a couple of days to find out, or something came in the mail. Guess what? That lien you filed after the bankruptcy was filed, even though you didn't have notice of it, is invalid. You're going to have to remove that, or it'll be void. So when I say the automatic stay is automatic, it happens instantaneously. If you ignore this, if you say, oh, well, you know what, I can, you know, I didn't open my mail for a couple of days, I'm still going to try to collect. No. You cannot ignore this. And if you try to collect monies from people in bankruptcy, despite the automatic stay, you can be subject to severe sanctions. Bankruptcy judges do not play. They are very aggressive, and attorneys such as myself, they're also aggressive. If somebody is trying to collect against somebody I put in bankruptcy, you need to be careful of it. You even need to be careful with your communications. If you're going to email somebody or a company that you're doing business with in bankruptcy, you're allowed to communicate with them, but it cannot be communication to collect monies. You can ask, hey, what's going on? Hey, who's your attorney? Get basic information, but you better not mention anything about money that's owed to you or trying to collect it. You will find yourself in a jam. Now, there are ways to go around the automatic stay and seek relief from it to do certain things. So if you're trying to remove some of your materials from a project site that's in bankruptcy, you may need to seek stay relief to do that. You may not be able to just go in and take your materials back if the debtor claimed an interest in them. It's extremely important that if you are owed money or you have materials you're trying to get back, that you pay attention to this, because to not pay attention to it and not address the automatic stay is to potentially suffer severe consequences. Now, let's talk about something everybody's got to be interested in. How do I get paid? Company files bankruptcy, property owner files bankruptcy, GC files bankruptcy. How do I get paid? Well, first and foremost, whenever there's a bankruptcy filed, in order to ever get paid from the bankruptcy, get any money, you need to file a proof of claim. Filing proof of claim is a fairly straightforward procedure. It's simply filing a form, filling out the form, stating how much you're owed and on what basis you're owed, and filing it with a court. There are ways for you to do that yourself. You can hire an attorney to do it for you. It's important to understand that the claim has the claim form, which I can send to anyone if they want it, has certain boxes that the mark you as either secured, unsecured, priority. So, for instance, what if you're an employee of a general contractor? I don't mean like a sub. I mean you're actually employed by a company to file bankruptcy, and they didn't pay your last week's wages. Well, you not only should you file a proof of claim, but if you're an employee, you're entitled to a priority claim, which means that you're going to get paid before other people. So you need to be careful to fill this out, and also review it very carefully and make sure you check the right boxes. It's also important to understand there is a deadline to file the proof of claim. You can't just file it whenever you want. You should look at that deadline, and it's on the website. There's ways to find out the deadline. You can check on a bankruptcy website or check with an attorney. In fact, you may receive in the mail a notice of what the deadline is. You cannot miss that deadline. If you miss that deadline, you're a late claim. And even if all claims get paid, let's say 80 cents a dollar, and your claim is late, you're not getting anything. You have worked hard to earn your money. You've done your work. You need to be paid. Don't work for free. File a proof of claim. Now, in a Chapter 11, sometimes there's ongoing work. So a good example is a janitorial service. So what if you're a company that provides janitorial services, you're a company that hauls away dirt or materials or brick or whatnot, and it's ongoing, and you have a weekly run with the general contractor. Well, if a Chapter 11 is filed and you're involved in it, they may want you to continue to do that, but you need to make sure that you are paid concurrently with your work. And it's called an executive contract, and I'll get to that in the next section, but you need to be aware of that. There are ways to get paid in a Chapter 11 post-petition, post-filing, but you need to make sure that you and the company filed bankruptcy are on the same page. Most importantly, make sure your lien is filed or bond claims are sent. You need to do that, and SunRay Construction Solutions does that. This is something, it's a very simple procedure that needs to be done. Protect yourself. File your liens as soon as you are legally able to protect yourself. By doing so, you'll put yourself in a better position. When you're a secured creditor, it's much better than being an unsecured creditor, trust me. Now, here's where it gets a little wonky, and I'll be very brief on this, but if you have a contract with a company in bankruptcy that exists prior to filing bankruptcy, they may want you to continue with that, and that's called an assumption in a Chapter 11 proceeding. If a debtor in bankruptcy is going to assume your contract, that means that they're actually allowed to pay you. In bankruptcy, the purpose of bankruptcy is not paying all debts, but what if you have an ongoing debt? You're paid weekly. So assuming on the day of filing that you're owed a de minimis amount of money, but you want to continue doing work, but you want to make sure that you get paid, well, guess what? There's an agreement you can enter into. It's an assumption of a contract or assumption of a lease in the bankruptcy proceeding, wherein even though they're in bankruptcy, you can continue to get paid as if nothing has changed. And that's what an assumption of an executive contract is. You shouldn't assume that it's business as usual. You need to address this immediately. At one point in time, I represented a company that provided services to help clean various construction sites, and they were paid on a weekly basis. They came to me after the Chapter 11 had filed, and they said, "Hey, can we keep doing this and getting paid?" Because they don't want to keep working and not getting paid. I was retained. I contacted the debtor's attorney, and they said, "Of course, we need your client services. You're a vital part of our business." And we entered into an agreement to assume the contract, filed it with the court. It was blessed by the court. The judge, smacked the gavel and said, "Okay," and we continued to do business. So in that particular instance, the bankruptcy did not affect my client because we dealt with it immediately and we got the contract assumed. Now, let's talk about just bankruptcy in general. Bankruptcies often get a bad rap. People consider bankruptcy as a business that has failed. Well, that's not exactly the case. What happens is a bankruptcy, especially a reorganization, can be used to stop various things: foreclosures, lawsuits, garnishments, creditor collection efforts. So what happens is your business may be making money, but some of your creditors may be soaking up more than what's coming in. Well, what happens is bankruptcy can give you breathing room until you can maybe ramp up your business, increase your business, and make a plan to pay creditors over a period of time. What happens is, and I've seen this a million times, I've represented, for instance, restaurants or small businesses that borrowed lines of credit from various different banks, and pretty soon there's just too much debt out there, and you have all these different creditors trying to get a piece of the pie. And what happens is it's multiple problems and multiple issues. Bankruptcy allows you to deal with all the problems in a central forum, and at the same time stop them from going after you. Stop them from either garnishing your bank accounts, stop them from calling you, harassing you. It gives you breathing room. The goal of bankruptcy is to create what's called a fresh start. And I have reorganized numerous businesses, and they all have emerged stronger. That's the goal of bankruptcy. factoring companies. I've seen a lot of small businesses borrow money from factoring companies, wherein they actually the factoring companies get a hold of their credit card receipts before they do. I've represented probably 5 pizza shops and various restaurants around here, and we were able to stop that, and in many cases reorganized. Lastly, if you do have valuable assets in your company and maybe you wish to shut it down, but you don't know what to do with the valuable assets, you can't just sell them and put the money in your pocket. There's a procedure such that you can shut down a business and not be accused of, let's say, fraud. You can sell those assets in bankruptcy through a 363 sale. There's a lot of opportunities, and if you own or run a company that is facing some financial difficulties, call me, call somebody who understands this process, call another bankruptcy attorney, get information. There's no downside in obtaining that information so that you can make informed decisions and go over your options. Lastly, personal liability. I've represented a lot of individuals who own companies, and a lot of times they're required to give their personal guarantees. It doesn't happen all the time, but it does happen quite often. So what happens is if you have a large amount of personal guarantees, and maybe you get stuck on a lease or business shuts down, and next thing you know, a landlord's suing you for $500,000, you don't have $500,000. Sometimes it's best to explore your options. In Florida has a tremendous amount of exemptions, and it may be that you can file bankruptcy and get rid of all your debts personally and not lose anything. And we can discuss this. Once again, it's important to speak with an attorney to go over options. Just because you file bankruptcy doesn't mean you will lose anything. I have put a tremendous amount of people into what's called Chapter 13, and they have kept every single one of their assets and saved hundreds of thousands of dollars. Every situation is unique. Lastly, let me point out that there's a big misconception on credit. I can't tell you how many times I've heard people say, well, if I file bankruptcy, I'm going to have no credit for 7 years. Nothing is farther from the truth. Your credit does not get turned off for 7 years. Yes, bankruptcy is a negative mathematical factor on your credit, but within 1 year filing bankruptcy, your credit score can go up tremendously. I've represented thousands of people over the years, and there has never been one person who says to me, I had no credit for 7 years. So that concludes our brief foray into construction liens and bankruptcy and how it affects various construction companies. With that, I would point out that if you do have or need to file a lien, you need to do it as soon as possible. You need to contact SunRay and take advantage of their fabulous software. And with this, I'm going to turn over back to Ariella. Thank you for your time.
Thank you so much, Jordan. So many of our customers are on this webinar, but those who are not familiar, we have an extraordinary online software. The first thing is that it is so easy to use. It only takes 60 seconds if you have the information in front of you to enter into the platform. It's extremely, as I said, it's extremely simple, very, very colorful. So there's nothing, you'll enjoy putting in the information as well to secure your lien and your bond claim rights. One of the most incredible parts about our online software are the deadlines. Everything is deadline driven. Clearly, this webinar discussed how essential it is to make sure that you lien quickly. You do not want to wait till the final hour. The SunRay platform will not only provide email reminders, the SunRay platform also has an entire deadline section for you, so you know when your last day when you can actually lien the project. So it's, again, extremely simple to use. The deadline reminders are incredible. And the final slide that we have here for the users are your waivers and releases. This is not to be, this is not, the word waivers and releases is specific to your notices to owners, not to your liens. So I want to make sure that everyone understands that when you lien a property, you record it in the county, has nothing to do with a lien. This is to your notices to owners, their waivers and releases, and you can think of them as like receipts for your payments. So, and you can do all of that for free on our online system. If anyone has any questions regarding our system, of course, feel free to give us a call. And at this point, this is a great opportunity for anyone on the webinar to feel free to ask an attorney a question without receiving a $6,000 bill in the mail right this minute. So if you have any questions, feel free to ask right now. And if you're nervous on the webinar, you are more than welcome to send Jordan an email. He is just spectacular. And Jordan, I want you to know that you did an incredible job. So while we wait, if anyone has any questions that they want to ask, just again, you did such a fabulous job on this webinar. It looks like you did, by the way, such a great job that no one at the moment has any questions.
Well, listen,
So,
my email is on there. You can see it on the slide. Anyone's welcome to email me. As I said, it's not a question of if you're ever going to encounter something like this. It's a question of when. In today's environment, invariably, you will have to deal with a bankruptcy in some form or another. I'm always here. I've been around for 24 years here in Boca Raton in South Florida. I handle everything from Vero Beach all the way down to Key West, because that's the Southern District of Florida. You can call me with any questions or email me.
thank you. Well, I wish everyone a fabulous and sunny day. Thank you, Jordan.